affects all those four.
I will show to your lordship it doesn't.
That you have just spelt out.
I will show to your lordship it doesn't when I come to each provision of the law. So these are the four restrictions. I'll elaborate on this, sir. But let me come.
Answer the initial question.
Yes.
Does it constitute an interference in the working of the Supreme Court?
Sir, I think yes or no. Sir, I would rephrase the question. The relevant question is, does it interfere in the internal working of the Supreme Court to the extent that it affects the independence of the judiciary?
Now,
That's the question.
You used the word supervise.
Yes.
Isn't supervision have an element of control?
My lord, any supervision will have the element of control, but control does not mean, regulate does not mean that you destroy the power.
How can you control without interfering?
No, any supervision will imply interference. The question is, does it colonize the other person's power? Does it destroy the other person's power? Does it violate the principle of the independence of...
Where the parliament has made a law that destroys the existing rules, what does it do?
My lord, it doesn't destroy the existing rules. Now that is a question which I will address. Relationship, अगर मैं सिर्फ competence अगर खत्म कर लूँ अपील की हद तक, मैं अपील की हद तक क्योंकि I
एक क्वेश्चन मेरा जरा ऐड कर ले छोटा सा.
जी.
Article 191 says subject to the constitution and the law. So what does that mean? The powers given to the Supreme Court by the constitution are absolute, or is there still a room for interference? Interference means amendment, or
I would not like to use the word interference because it gives...
It's not interference, yes. I'm sorry for that.
I would say that your lordship...
But still the rules are, the power which has been given to the Supreme Court, is that power absolute?
No, it's not absolute.
Because the first word is subject to.
Yes. Subject means conditional. It is a restriction. It can't take over the power to take rules. It can't paralyze that. That is why I would say that the Supreme Court should be insulated from external pressure. It should not be isolated. So Article 191 creates this balance where the internal autonomy of the Supreme Court stays in the hands of the Supreme Court, but subject to certain restrictions which may be imposed, and certain conditions which may be imposed by Parliament. I'll come to, because this is a crucial question, and there is a Supreme Court judgment on this, the relationship between rules and act and what prevails. I'll come to that.
If I've understood you correctly, what you're saying is that this is not this law-making power, or law as used in 191, is not a fully enabling power, but it is a power of a supervisory nature. Is that what you're saying?
It is a restrictive power.
You use the word supervisory.
Yes, I use the word supervisory in terms of that it is a power which has its limitations. That is why...
One reason why I'm asking this is because we are emphasizing on linking this with entry 58.
Yes.
Which you say should be interpreted in the usual way that the legislative entry is normally interpreted.
Yes.
That would seem to necessarily imply that whatever is the subject matter of that legislative entry, it is not as such disclosed in 58, but I imagine would then be the practice and procedure of the Supreme Court. Then surely, if you read it the way you are linking it, then that would, the law-making power would cover the whole of the field of the practice and procedure of the Supreme Court, and thereby, just hang on, thereby become an enabling power and not remain a supervisory or restrictive power of the nature that you are now stating. So there is this tension between what you are saying, a possible conflict. Kindly clarify this point.
My lord, there is no conflict because the language of entry 58 clarifies. Entry 58 cannot go beyond the conferment of power with necessary implication which any article of the Constitution does. So any power in terms of legislation which entry 58 does must be in the context of the power conferred by the Constitution. So if 191...
But that power, in the end, legislative entries confer power, legislative competence over a subject matter.
Yes.
A tax on income.
Yes.
The defense forces, international relations, what have you. The entry 58 of itself discloses no subject matter as such. It simply refers, because this is the point
That is why it is limited by that constitutional provision which confers this power.
then how do you read it as a legislative entry? Because if you now link it to the subject matter of practice and procedure, that then should
Sir,
surely
if you
covers
don't
the
read it
whole
as a
of-
legislative entry, you will make part of the entry redundant. The part of the entry says or relate to the federation.
That's what I'm saying. That
I mean, it
if-
makes it redundant.
No, it doesn't make. That's my question to you.
Yes, yes.
आपकी जो submission है,
जी,
मुझे
जी,
समझ
जी,
आ
जी,
रही है
I'm
ना।
sorry, sir.
That seems to me not to be restrictive or supervisory. That would necessarily, if you link it to a legislative entry and the manner in which legislative entries are interpreted, that would have to be given the legislative competence, the power to make the law, the enabling power, whatever you want to put it, would, it seems to me, have to be interpreted in the broadest possible manner, which would mean that it would cover the whole of the field of practice and procedure, which is why Mr. Salahuddin, for example, said that yes, the Supreme Court rules can be repealed by an act of Parliament.
No, I don't take that.
Don't go there.
No,
I understand.
I don't
That's
take
why I'm asking you.
Yes.
So there is this tension
Yes.
between linking it to a legislative entry, because that's how legislative entries are interpreted, and then in the same breath or in the next breath, saying that no, it can't go to the full subject matter. It is restricted to supervisory or limited nature.
Mr.
How
Lord,
do you draw the line?
these are entries which I call ping pong entries, and I'll explain when it come to.
Mr. Faisal,
Ji.
taking the discussion further, and that's very important, what's being discussed. My understanding is, what appears to me so far is that when we have to read 191, straight away when you look at 191, there could be a restrictive meaning given to law, but we don't have to really stop there. We could also say that there could be a law, even plain reading of 191, that there could be a law that would cover the area of practice and procedure, because that's why it's subject to that law. There is a law, whenever Supreme Court goes ahead and comes up with rules, it will look at law. There could be laws relating court fee, there could be laws relating to many things that impinge upon, but at the same time there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, makes it very expensive. It says that it covers, it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is a legislative competence with the Parliament to legislate on the question of practice and procedure.